to thank Bill for his very generous remarks. I'm reminded of a incident involving Judge Learned Hand, who was, as you recall, the Chief Judge of the U.S. Court of Appeals for the Second Circuit and one of the most distinguished judges of the 20th century. On the occasion, I believe, of Hand's 70th birthday, there was a great commemorative event for him, a great banquet in his honor in New York, and where Supreme Court justices came and many federal judges came and prominent lawyers came. The evening was spent paying tribute to him. One after another of the speakers extolled Hand's great virtues. Finally, at about 11 o'clock, they finally called on Hand to say something. And he stood up and he said, "You know," he said, "I really have been very embarrassed by all of the nice things that have been said to me here tonight." And then he paused, he said, "But I have to admit, I've enjoyed every minute of it." I feel privileged to present a lecture that honors the memory of Justice Robert Jackson. I include myself in the large legion of his admirers. I think it's especially appropriate that the subject of my remarks this afternoon is lawyers. I say that because Robert Jackson was a lawyer par excellence. As the Solicitor General of the United States, he was the federal government spokesman before the United States Supreme Court. He was, without question, one of the very best advocates to appear before the Supreme Court during the 20th century. Indeed, there are a number of people who believe that he was the very best advocate to appear before the Supreme Court. He spoke with unusual, exceptional elegance. He wrote and spoke with exceptional elegance and power. I especially enjoy a story he liked to tell about the fact that in every case he said he argued before the Supreme Court, he said he made three arguments, three oral arguments. The first was the argument that he prepared in his office as Solicitor General, and that argument was very well organized, was very lucid, very persuasive. The second argument was the argument he actually made before the court when he was frequently interrupted by questions before the justices. And as he described it, it was frequently incoherent, illogical, discursive, and not very convincing at all. And finally, he said the third argument, and the very best argument by far, was the argument he made that night after the oral argument when he was taking a shower at night. And the argument he said he presented was brilliant, lucid, and the answers to the justices' questions were crisp and incisive. So I like that story because I think it reflected something very human about Justice Jackson. During this spring, during the past several months, various organizations throughout the country, including the Department of Justice, various law schools, public defender offices, and other organizations have sponsored events commemorating the 50th anniversary of the Supreme Court's decision in Gideon against Wainwright on March 18, 1963. As you know, the Supreme Court decided in that case that pursuant to the Due Process Clause of the 14th Amendment and the assistance of counsel provision in the 6th Amendment, the state courts are required in every felony case, every case that will result in imprisonment, to provide a lawyer to an indigent defendant. I was privileged to participate in the case. I was a young partner in the law firm of then Arnold, Fortas & Porter, and my senior partner, Abe Fortas, was appointed by the Supreme Court to represent him. As I will describe to you, he asked me to assist him. So I had a ringside seat, so to speak, at this case. What I want to do this afternoon is to describe to you the problems we confronted in representing Clarence Gideon before the Supreme Court and the manner in which we resolved those problems. I also want to locate the Gideon case in the mainstream of constitutional law, that is to discuss with you how it fit into the broader events that were occurring during the Warren Court's efforts to reform the administration of criminal justice, especially in the state courts. Then I should point out that during the various events which I have attended this spring in commemorating the Gideon decision, almost invariably some commentator will say at these events that the Gideon decision has not fulfilled, the high expectations surrounding Gideon have not been fulfilled. And that is regrettably true. And I want to discuss why that is true. That is, what are the factors that account for the fact that we still have many defendants who are not adequately or competently represented. And then I want to discuss with you some proposals or things which I think we could consider doing in order to improve an effective system of the representation of indigent defendants. I know that, I assume that every one of you probably at one point or another in law school would have read the case, but allow me to take just a moment at the outset to refresh your recollection of the facts in the Gideon case. Gideon was charged in a Florida state court with breaking into a pool room. It was a felony under Florida state law. And he was indigent, and when the trial commenced, he stood up and he said to the judge, "I ask you to appoint a lawyer to represent me." The trial judge rejected his request on the grounds that under then existing Florida law, a lawyer would be appointed for an indigent defendant only in a capital case, that is, only in a case involving the death sentence, and this was not, of course, such a case. So Gideon conducted his defense as best a layman could. He was found guilty by the jury, and he was then sentenced by the court to 5 years in prison. While he was sitting in prison in Rayford, Florida, he sent a 2-page handwritten letter to the Supreme Court asking the Supreme Court to review his case on the grounds that his constitutional rights had been denied because the court refused to appoint a lawyer to assist him. The Supreme Court gets hundreds of such informa pauperis petitions every year. And Gideon's petition was plucked out of this great mass of petitions, and the Supreme Court granted certiorari and agreed to review Gideon's case. At the same time, it appointed Abe Fortas as the lawyer to represent Gideon. Now, when the Supreme Court grants certiorari and agrees to review a case involving an indigent petitioner, a prisoner like Gideon, it's the practice of the court to appoint a lawyer to represent that party before the Supreme Court. The court doesn't give any explanation at all of why it appoints that particular lawyer. So we're forced to speculate on why did the court appoint Abe Fortas in this particular case. I should tell you that Fortas was very close friends, very, very close friends with Justice Douglas, going back to their days together at the Yale Law School in the early 1930s. And he also knew personally a number of the other justices. I think it's fair to say that the Supreme Court regarded the Gideon case as an important case, and it wanted to appoint a leading advocate to present the argument on behalf of Gideon, and Fortas certainly met that specification. Measured by any standard, Fortas was one of the best lawyers of his generation. Now, apart from the fact that he was a superlative appellate advocate, I believe there was another reason, I suggest, why Fortas probably was appointed. That is because he was widely known. He had a reputation of being a pro bono or public interest lawyer. During the early 1950s, as you may recall, the government was engaged. There were what was called the loyalty and security proceedings involving charges against government employees. And various government employees would be brought before loyalty and security boards on the basis of magazines they had subscribed to in college, or organizations they had belonged to in college, or friends they had had in college. And they would be charged with being disloyal or a security risk to the United States. And Fortas was deeply offended by this, and he took the lead in our firm in representing such people pro bono. Let me say, it took a lot of moral courage to represent such parties. Many lawyers shunned such cases because they were fearful that clients would regard them as communist sympathizers and would abandon them as lawyers, but Fortas stood up for it. Now, there was another thing that marked him out as a pro bono lawyer. In 1953, the U.S. Court of Appeals for the District of Columbia had a case before it involving the question of what is the standard of criminal responsibility. That is, how should the insanity defense be defined in a criminal case? The case involved an indigent petitioner, and Fortas was appointed by the Court of Appeals to represent the petitioners. His name was Monty Durham. Fortas knew many psychiatrists, was interested in developments of psychiatry and the law. And he wanted the court to change the existing test. The existing test in 1953 in the District of Columbia and many states throughout the country were what was called the McNaughton test. If a defendant claimed that he was of unsound mind at the time of a criminal offense, the question was, did he know the difference between right and wrong? That's the McNaughton test. That test was obsolete in terms of the insights of modern psychiatry. And Fortas argued that a test of insanity should take account of the knowledge and developments of psychiatry, and it should permit psychiatrists to tell the court everything that they knew about the defendant. The Court of Appeals agreed in that case and issued an opinion, a famous case, the Durham case, and said, well, the test should be applied as whether the crime was the product of mental disease or defect. And it ignited a debate concerning the insanity defense, which has gone on to this day. But the point I wish to make was that Fortas, as I say, was well known as a pro bono lawyer. Now, a day or so after he was appointed by the Supreme Court in June of 1963 to represent Gideon, late June, he summoned me to his office, and he told me I'd been appointed, he said, by the Supreme Court to present this case. I want you to take charge, he said, of the research and help me to write the brief and present the argument on behalf of Gideon. I'd been privileged to work with Fortas for about a decade on many matters. Before this event, I'd come to the firm as a young lawyer in the early 1950s, so I'd worked with him on many matters. And I can vividly recall what he said to me that morning about what he wanted me to do. He said, look, I want to know everything about the right to a lawyer since the invention of money. And he meant every word of it. A day rarely passed in which he wouldn't call me and say he wanted to know what about the right to counsel in Russia, or what about the right to counsel in England in the 19th century. And he ranged over, he wanted to know in great depth every aspect and facet of the right to counsel. Now, as Gideon's lawyers, we had the responsibility to present every argument, every legitimate argument that we could make to secure the reversal of his conviction. But Fortas made absolutely clear to me from day one that his objective in the case was to convince the Supreme Court to establish the principle as a matter of constitutional law that in every case, felony case, if a defendant was indigent, he was entitled to have a lawyer appointed to assist him. And that was the overriding objective from day one. Now, there were two other young lawyers who joined another firm who assisted me in helping Fortas. One of them was a man by the name of Ralph Temple, who later became the head of the Washington office of the American Civil Liberties Union in Washington. And the other individual who assisted me was a young student who was a third-year law student in the Yale Law School who had come to work in our firm as a summer law clerk. And upon his arrival, he was immediately assigned to me to help me respond to Fortas' request. His name was John Hart Ely. John Hart Ely later became one of the most distinguished legal scholars in the United States. He became a professor at the Yale Law School, a professor at the Harvard Law School. He was the dean of the Stanford Law School. And he wrote a book in 1980, Democracy and Distrust, which is a classic in the literature of constitutional law. So the three of us, we were the ones who helped Fortas. I'm the only survivor of this quartet. I'm, so to speak, the last of the Mohicans. And in that capacity, I'll tell you about the case. In order to assist you in appreciating the problems we confronted in representing Clarence Earl Gideon, I have to take a few minutes to describe for you the status of the right to counsel as a matter of constitutional law in the summer and fall of 1962 when we were writing the Supreme Court brief. There was a fundamental difference between the right to counsel, constitutional right to counsel in the federal courts, and the right to counsel in the state courts. In the federal courts, it had been established in the 1930s that in every case, regardless of the nature of the offense or the character of the offender, that the federal court was obliged to provide a lawyer to an indigent defendant. And if the court failed to do that, the judgment was void. The court lacked jurisdiction, and the judgment would be invalidated. That was the rule in the federal courts. The situation in the state courts was altogether different. In the state courts, it had been established beginning in the 1930s, following the famous Scottsboro case in Alabama, that in a capital case, in a case involving the death sentence, an accused person who was an indigent had to be provided with a lawyer. But in all other cases, in all non-capital cases, there was no obligation, no constitutional duty on the part of the state courts to appoint a lawyer for an indigent defendant. That principle, the principle I've just described, was confirmed by the Supreme Court in a case in 1942 entitled Betts against Brady. And the majority of the Supreme Court decided in Betts against Brady that a lawyer had to be appointed in a state court felony prosecution for an indigent defendant only if there were special circumstances in the case, such that after the case, if the defendant didn't have a lawyer, one could say, the trial was unfair. It subsequently developed that special circumstances meant, well, was the defendant a juvenile, or was the defendant mentally incompetent, or was this an unusually complex case? But in the great majority of felony cases in the state courts, in the period I'm talking about now, we're talking about the 1940s, 1950s, there was no constitutional obligation on the part of the state court to appoint a lawyer for an indigent defendant. And the Brady case, for example, involved a prosecution in Maryland for robbery, and the defendant was convicted and sent to jail for a long term. Many defendants, countless numbers of defendants, were convicted in state courts throughout the United States in the period I'm talking about. We're talking about the 1940s, 1950s, who were indigent and didn't have a lawyer and were sent to jail. Now, in constructing the argument on behalf of Gideon, we had to deal with basically two problems. Number one, we had to deal with the problem presented by adverse precedent, bets against Brady. That is to say, we had to deal with the fact that up to that point, a lawyer had to be appointed by a state court only if there were special circumstances. Now, let me say, when the Supreme Court granted certiorari in the Gideon case, it said to the lawyers, issued an order saying, we want counsel to discuss in their briefs and oral argument whether bets against Brady should be reconsidered. And I'll explain how that was a very significant order, I should say. Now, so first we had to deal, as I say, we had to deal with the question of precedent, which was adverse. Second problem we had was basically a question of federalism. A decision by the Supreme Court, bear this in mind, a decision by the Supreme Court that counsel had to be appointed by the state courts in every felony case would have been an intrusion by the Supreme Court into the administration of justice in the state courts. It would have obliged the states to appropriate money to pay for defense counsel. So there was a very serious question of states' rights or federalism that was right at the heart, believe me, was at the heart of the Gideon case. Now, I will discuss in turn how we dealt in turn with each of these two issues. The issue, I'd say, number one, of this adverse precedent, of the special circumstances, and two, the issue of federalism. We carefully studied the trial record in the Gideon case. That was obviously Genesis 1:1, you had to study the trial record. The trial record was very skimpy, and it was very obvious to us that there were no special circumstances in Gideon's case. He was a middle-aged man in his late 40s. He was average intelligence. He was not mentally incompetent. And let me say, he also had a good deal of experience, prior experience with the criminal courts. Now, neither Abe Fortas nor I ever met Gideon. We never met him. But there's a long letter from Gideon to Fortas, which Gideon sets out his whole life story and background, which was reproduced in the famous book about the Gideon case. It's called Gideon's Trumpet, which I think many of you may have probably read, maybe before you went to law school, by Anthony Lewis. And if you read the letter, and you can see what kind of a person Gideon was. He was a drifter who was in and out of the criminal courts. Now, but the point was there were no special circumstances about the Gideon case. It was a plain vanilla case. And that was just the hard fact about it. Now, it was obvious to us, for several reasons, that this 1942 decision in Betts against Brady, the special circumstances test, was on very wobbly legs. In the first place, 4 of the Supreme Court justices, 4 of them, in a year or two preceding the Gideon's decision to grant certiorari, 4 of them had made clear that they felt Betts against Brady should be overruled. That was true of the Chief Justice Warren, Justice Brennan, Justice Douglas, and Justice Black. The special circumstances test was a singularly bad test because it was so vague and ambiguous. It invited endless, what was a special circumstance? The courts were endlessly involved in litigation as to what was special circumstance. Second place, we knew that the Betts against Brady test was a very, very life support system, was the fact that the Supreme Court had granted certiorari in the Gideon case. In other words, by agreeing to review the Gideon case, the question in the Gideon case was, did a defendant in an ordinary felony case have the right in a state court where he's indigent to appoint a counsel? And you don't get certiorari unless you get 4 votes. So, and the fact that certiorari was granted meant that at least 4 justices of the Supreme Court felt there was a serious and substantial question presented by whether or not a defendant was denied his constitutional rights in a state court if he was indigent and didn't have a lawyer. Finally, as I noted earlier, the Supreme Court, in the order, issued its order at the time it granted certiorari in Gideon, it said, we want the lawyers in this case to discuss, in the briefs and oral argument, whether Betts against Brady should be overruled. And that was a clear signal to us. That was an unmistakable signal to us that Betts against Brady was on life support. Now, we made a calculated decision. In our brief, we attacked the decision of Betts against Brady head on. We urged the Supreme Court overrule Betts against Brady. We challenged the basic premise of the Betts against Brady decision, which was that you can have a fair trial if the defendant lacks a lawyer. We argued, we said, look, no person can have a fair trial, no criminal defendant can have a fair trial unless he has the assistance of counsel. That a layman cannot possibly evaluate the validity of the indictment or the charge against him. He doesn't know whether a search and seizure is reasonable or not. He cannot possibly know whether or not a confession is admissible. He knows nothing about the rules of evidence or how to cross-examine witnesses. He doesn't know anything about making a closing argument. And he's really basically helpless. And Justice Douglas, I think summarized it very aptly when he said, a criminal prosecution confronts a layman with a labyrinth he can never understand or negotiate. That's exactly right. Now, we next argued that there was no legitimate basis for the distinction that had been made between the right to counsel in capital cases and in non-capital cases. Indeed, it was irrational because in many non-capital cases, the issues were far more complex even than in a capital case, so that there was even a greater need in a non-capital case for a lawyer. We then turned, after dealing with this Betts against Brady precedent, we then turned to what was really the critical central issue in many ways in this case, and that was the issue of federalism. Let me say, in the early 1960s, at the time the Gideon case was before the Supreme Court, there was a tremendous debate going on among the justices of the Supreme Court about the extent to which the various provisions of the Bill of Rights, which applied only to the national government, should be extended to the state courts. The issue in a nutshell was this: should such provisions in the Bill of Rights as the privilege against self-incrimination, or the prohibition against cruel and unusual punishment, or the prohibitions against double jeopardy, all these various provisions in the Bill of Rights that deal with criminal procedure, which applied in the federal courts, should those also be made applicable as a matter of constitutional law to the state courts? Now, Justice Black had written a famous opinion, which probably in law school all of you remember, written a famous opinion in a case called Adamson against California, in which he said, I have studied the history of the 14th Amendment. He said, I am convinced, Justice Black wrote, that when the 14th Amendment was adopted, it was understood that all of the Bill of Rights were to be made applicable to the states. But Black's position was a minority position. The majority of the court didn't agree with him. And what happened was that only a few of the Bill of Rights as of 1963 had been made applicable to the states. Now, viewed in one way, think of it this way, viewed in one way, the question presented in the Gideon case was whether the right to counsel covered by the Sixth Amendment, in every case, every criminal case, the accused shall enjoy the assistance of counsel, whether that right was made applicable to the states, the state courts, by the due process clause of the 14th Amendment. We didn't want to, let me say, we thought about this very long and hard. We didn't want to get caught up in a crossfire among the justices of the Supreme Court as to whether or not the Sixth Amendment was made applicable to the states, absorbed or incorporated by the due process clause. We knew that some justices would support that view. We knew that we were concerned that other justices we knew from what they'd written would oppose that view. And so if we walked into that, we'd walk into a crossfire. We wanted to stay away from that. Instead, we made a simple argument. We said that put to one side whether or not the Bill of Rights is applicable to the states. If you just consider the provision in the 14th Amendment, no person shall be deprived of life, liberty, or property without due process, that provision, standing alone, standing on its own bottom, so to speak, independently of the Bill of Rights, meant that you can't have a due process, meant that you can't have a fair trial unless the accused person who is indigent has a lawyer to represent him. And so we made just that straightforward argument. Now, in this connection, there are 2 points that I wanted to point out that we made. First, we said to the Supreme Court, look, if you decide, as we have urged, that the state courts must appoint, as a matter of constitutional law, a lawyer for a defendant in every felony case, you're not going to be changing procedure in the state courts very much. The fact of the matter was that as of 1962, in 45 of the states, counsel was provided to defendants, to an indigent person in every criminal case of all types. It was not done pursuant to the federal Constitution. It was done pursuant to the state Constitution, or pursuant to state Supreme Court decisions, or pursuant to state court rules. So in 45 states, it was already the practice to provide a lawyer for defendants. And therefore, if you were to say, you now, as a matter have to do as a matter of federal constitutional law, that's not going to be a big bump in the road. Even as the 5 outlier states, those states which didn't provide a lawyer for a defendant in a non-capital case, they did provide a lawyer in a capital case, so that what we're saying to the court, look, if you agree with what we're saying, this is not going to be a revolutionary change, so don't be concerned about that. And we were strongly supported in this point of view by the fact that 22 state attorney generals filed an amicus brief, an unusual amicus brief, supporting our position, saying we agree that accused persons in state court should have a counsel to assist them. Now, secondly, Fortas had a brilliant insight about this federalism issue. He said, look, under the special circumstances test, what happens is this. Defendants are tried and convicted in a state court. The conviction is affirmed by the state Supreme Court. And then the defendant has a lawyer who immediately walks down the street to the federal court and files a petition for habeas corpus. And the federal judge now reviews what the state court judge did under a special circumstances test. So that means he reviews every case, case after case. That's what was going on. Defendants would be convicted in a state court, and then the lawyers would come into the federal court and ask for habeas corpus to review it. And what was the test? Special circumstance. And Fortas pointed out, look at this test. It's a test which applies ad hoc, case by case, special circumstances, case by case. And also ex post facto, you're looking after the trial. And he said that really is very intrusive on states' rights, much more intrusive than having a simple rule that the state courts must provide a defendant to a lawyer in every felony prosecution. Now, the oral argument which Fortas made is recorded, and you can listen to it. It's readily available. Let me just say about it that Justice Douglas, in his memoirs, which were written some years later, and Douglas had been in the court for 36 years, he said in his memoirs that the single best argument in my time on the Supreme Court was made by Abe Fortas of Gideon against Wainwright. Now, you have to make a due allowance for the fact that Fortas and Douglas were very good friends, but so you know, you should maybe discount this a little bit. But even so, that's very high praise indeed. Now, following the oral argument, following the conference of the court where the vote was taken, the Chief Justice Warren, assigned the writing of the majority opinion to Hugo Black, Justice Black. It was a most appropriate designation. I say that for these several reasons. First of all, Black had written the opinion of the Supreme Court in the 1930s, a case called Johnson against Serps, which said that the federal courts must provide a lawyer in every case. He wrote that opinion. And in 1942, when the Supreme Court decided Spetz against Brady, Black wrote a dissent. He disagreed. He said, no. He said, a defendant is entitled in every case to a lawyer. And he had made very clear that he thought Spetz against Brady should be overruled. So he was a very logical choice as the author of the Gideon opinion. Now, Black's opinion in the Gideon case is typical of many opinions that Justice Black wrote. It's brief, it's free of legal jargon, it's intelligible to a layman, and it comes to the point very, very incisively. But essentially, the opinion in the Gideon case, Justice Black makes 2 points. He says, the first point is, he says, no defendant can have a fair trial if he is not represented by counsel. A court is not properly constituted unless it consists of a trial judge, a prosecutor, and a defense lawyer. That's a properly constituted court. Now, you have to bear in mind something about Justice Black's background. He had been a lawyer in Birmingham, Alabama, at the turn of the century. It was a tough and violent steel town, let me tell you. And Black he'd been a defense lawyer, he'd been a prosecutor, He'd been a county court judge. So Black knew from personal experience how important it was to have a lawyer. In other words, he came to this case with a great deal of background as to the importance of counsel. The second place, there was a second aspect of it that I think I need to point out. The Gideon opinion reflects Black's profound empathy for those persons who were disadvantaged and poor. It was absolutely unacceptable, just unacceptable to a justice like Hugo Black, that a person should be denied justice because he didn't have adequate funds. To Hugo Black, a lawyer was not a luxury, it was a necessity. And his opinion just, if you read his opinion, just resonates with that attitude. Now, in the biography, there's a biography of Justice Black written by Roger Newman, and he describes the scene in the Supreme Court on the morning of March 18, 1963, when the Gideon decision was handed down. Let me just quote from it. I'm quoting now from this is the biography of Black by Roger Newman. He said, "When Chief Justice Warren called on Justice Black on the bench, Black leaned forward and spoke in an almost folksy way, reading sections of his Gideon opinion. Happiness, contentment, gratification filled his voice. When Betts against Brady was decided, he said a couple of weeks later, I never thought I'd live to see it overruled. It was indeed a moment of supreme satisfaction, one of the highlights of Black's years on the Supreme Court." Now, as a matter of constitutional law, I want to step back for a minute. The Gideon decision was significant. Why? For several reasons. First of all, it filled a gap in constitutional law with respect to the right to counsel. The gap had existed that state courts were not required in non-capital cases to provide counsel to injured defendants. So it filled that gap. That was the first thing it did. But the Gideon decision was also consequential in a much more profound, let me put, or broader sense, let me put it that way. It was a key link in the efforts by the Warren Court, by the court headed by Chief Justice Warren, to reform the administration of criminal justice in the state courts and to establish the principle that the rules of law in criminal cases should be the same in the federal courts as in the state courts. Now, one of the principal things, one of the principal objectives of the Warren Court was to, one of the things they wanted to do was to protect the rights, particularly felt the rights of poor persons and particularly of minority persons who they felt had been treated unjustly, particularly in the state courts. And this was to be accomplished. How were they going to protect those rights? It was to be accomplished by extending the various provisions of the Bill of Rights, which have been applied only to the federal courts, by extending them to the state courts. Now, in the Gideon case, the court decided that the Sixth Amendment's guarantee of the right to counsel is applicable to the state courts pursuant to the Due Process Clause. And in the years that followed the Gideon case broke open a logjam. In the years that followed, what happened was that the Supreme Court decided, case after case, that various provisions of the Bill of Rights, such as the prohibition against double jeopardy, the prohibition, the protection against self-incrimination, the right against cruel and unusual punishment, all of those rights, which had been applied only in the federal courts, now also applied in the state courts. So that the Gideon case was, you have to think about it as a very critical step in this process of having a system of justice in the United States where we have the same rules of law, constitutional rights apply in the state courts and in the federal courts. There were several aspects, let me point out, of the right to counsel that we didn't address in our brief. First of all, we said a defendant was entitled to have a lawyer to represent him. Let me say, it became perfectly evident that's not adequate. You have to have, in a criminal case, you have to have a lawyer who's competent to try a criminal case, not just any lawyer. Secondly, that lawyer has to be provided with adequate funds. Adequate funds so we'll have an incentive to investigate the matter, adequate funds so we can hire experts, which are essential in any criminal case now, any criminal case, and we didn't focus on that. We also, let me tell you, we did not foresee all the questions and issues with respect to the right to counsel in plea bargaining, an issue which has only emerged in the Supreme Court in the last couple of terms. It's something I will say a little more about in a moment. And of course, we did not address the right to counsel, all the issues of the right to counsel in civil proceedings. Let me say some very fundamental rights of very great importance can be involved in a civil proceeding where a defendant doesn't have the assistance of counsel. Now recently, as I noted earlier, at events commemorating the 50th anniversary of the Gideon decision, various commentators will say, well, they say the Gideon decision has not fulfilled the high expectations that we had, the high hopes we had have not been realized. Now, I have to acknowledge that is regrettably true. The Gideon decision did invigorate the public defender movement. It inspired it. It did definitely improve the representation of defendants throughout the country to some extent. No doubt about that. It did improve it. But the fact remains, it's undeniable, it's incontrovertible, that large numbers of defendants throughout the United States are still not adequately or competently represented. That just is a fact that I do not think any fair-minded person can possibly deny. Now, let me say, this same observation about hopes not fully realized could also be made about another, but perhaps the greatest Supreme Court decision of the 20th century, the decision in Brown against Board of Education. The great high hopes that many of us had about that case also not been fulfilled in many respects. And the fact that the hopes have not been fulfilled, I suggest to you, does not diminish the luster or greatness of the Brown decision or the Gideon decision. Rather, it's a wake-up call that we have unfinished business to attend to. We have unfinished business with respect to the Brown case and unfinished business with respect to the Gideon case. Now, why has the promise of Gideon not been fulfilled? That is, why is the trumpet muted? Why are there a large number of defendants who are still not competently and adequately represented? What explains what's going on? Well, first of all, the Gideon decision, the Supreme Court's decision in the Gideon case, contemplated that state legislatures would appropriate the funds necessary to pay lawyers to represent indigent defendants. But there was a big gap in the Gideon decision and subsequent decisions. There was no mechanism provided for enforcement of that particular obligation. And the court didn't say what level of funds or what the state legislatures had to do. It left it wide open. And so that was a tremendous gap in the decision. Now, the fact is that many public defender offices throughout the country, and let me say many of the public defender offices do a fantastic job really in representing criminal defendants, but the fact is that many of them are understaffed. The caseload is overwhelming. They can't adequately train people because they are not adequately financed. And the fact is that money for indigent defendants is a matter of very low priority in the budgets of many state legislatures. A second reason why the Gideon decision has not been realized, let me say to you, is this. There have been profound changes in the criminal law system since 1963. A great many activities, especially those relating to drugs, have been criminalized since 1963, with the result that vastly many more persons are swept up into the criminal law system than was the case in 1963. The Gideon decision contemplated that there would be jury trials of a large number of criminal cases. But today, nearly all criminal cases, nearly all criminal charges are resolved through plea bargaining. First of all, if you look what's going on. You have the proliferation of criminal statutes so that the same act can be declared criminal under a variety of ways. And in addition, you have now minimum sentences, mandatory sentences. And with the result of what's happened since 1963, that enormous power, enormous discretion is vested in prosecutors. We presently, let's be candid about it, we presently have an assembly line system of criminal justice in our country. We don't have a system of criminal trials anymore, which is what Gideon contemplated. And it's extremely difficult for courts, let me say, to supervise. It's very hard for a conscientious judge, federal state judge, to supervise plea bargaining. After all, plea bargaining goes on behind closed doors, and there's no record, and it's very tough to get at. Now, one of the major challenges that is now confronting the criminal law system is how to ensure that defendants are competently and adequately represented in a system that is dominated by plea bargaining. Now, another thing that's happened that has affected the way in which Gideon is implemented, and that is the Supreme Court really significantly eroded the standard of competent representation in a case decided in the 1980s called Strickland, where the court said that there's a strong presumption of competence on the part of defense lawyers, and that defendant complaining of ineffective counsel has to show that if he were competently represented, the result would have been different. And the court has applied a very minimal standard. The courts have tolerated, let me say, egregious, really egregious examples of incompetence. Now, finally, there are some technical rules which have come into play, which were fully appreciated. Let me say particularly, there are two rules. One is that a defendant is deemed to be bound by the decisions in most instances of the things his lawyer does, even though whether he chooses him or not, he's bound by those decisions. And in second place, the rules with respect to habeas corpus, the procedural rules governing habeas corpus have become so complex and they're so still so difficult that there's very little supervision, or much less supervision, of the state courts through habeas corpus than would have been the case in 1963. I have to say to you that in my view, there is a basic underlying factor. There's a political reality that accounts for why the states have not really adequately, many states, and that's not true of all states, but many states have not adequately financed the effective representation of counsel. I submit to you that there is no effective political constituency for the right to counsel for indigent defendants. Ask yourself this question. Who are the persons most adversely affected by a system of justice which doesn't provide lawyers for indigent defendants? Who are these persons? Primarily, they are poor persons, mostly from minority groups, many of them very poorly educated, illiterate, poorly educated, with no political clout. Approximately 80% of persons charged with crime are poor. Those are the statistics which are unquestioned. 70% of them don't even have a high school education. And let me say this, the astronomical number of young black men, who are now in prison, as I suggest to you, is indefensible, morally indefensible in our country, and has to be re-examined. It is estimated, let me say this, we now have estimates that 1/3 of all young black men who don't go to college will end up in jail. And a system of that sort simply is indefensible. And the impact of that is just, the costs of that are just enormous. If the Gideon decision is going to be effectively implemented, there are going to have to be different steps that are going to have to be taken. First by Congress, second by the courts, third by private individuals. Let me say what I think needs to be done. In the first place, Congress, we need to examine we need to decriminalize a number of things, get those out of the system, so that the criminal courts are not overwhelmed with matters which really properly should not be part. I say that particularly of drug offenses which don't involve violence. That has to be re-examined, it seems to me, by fair-minded persons. Secondly, I believe that a public defender system should be established in every state, and the state legislatures need to accept the responsibility to fund such a system. In the same way that you fund a prosecutor's office, you have to have a parallel office, a public defender. I mean a public defender system which is adequately financed, where people are adequately trained, and where the dockets are not overwhelmed. Third, I'd say the courts have to re-examine the standard of effective representation. It should not tolerate the incompetent and ineffective representation. The representation of defendants, I suggest to you, in plea bargaining is going to emerge. That is going to be the great battleground of the right to counsel in the years to come. Given the huge number of cases, almost the vast majority of cases are now administered through plea bargaining, and the courts now have a responsibility, I suggest to you. The Supreme Court has said there is a constitutional right, ruled several times, that there's a constitutional right to effective counsel in plea bargaining, and that's going to be a very tough assignment, as I pointed out, for the courts to really supervise and administer that. But that, in my judgment, this plea bargaining, that's the great battleground where the right to counsel is going to be fought out. Fourth and finally, let me say this. The effective implementation of Gideon is the responsibility of the bar associations, it's the responsibility of the private law firms, it's the responsibility of the law schools to stand up and make clear why, and these groups need to unite with other groups and organizations which are committed to the idea that a fair trial in our country, the principle established by Gideon is you cannot have a fair trial unless a defendant is adequately and competently represented. If these various things I suggest are done, perhaps in the years to come, we may see that the great and high hopes of the Gideon decision really finally come to be implemented. Thank you very much.
Thank you. Abe, I'd like you to stand and present to him this plaque in commemoration of the Distinguished Service Award in recognition of his commitment to the advancement of justice. Thank you, Abe. We do have just a few minutes for a question or two. He and his wife are coming to the dinner tonight, so any of you can talk to him then. But does somebody have a question? He'd be glad to answer it. Yes?
I would like to know his opinion on the Turner versus Rogers case from the Supreme Court regarding the possible right to counsel of a defendant in a child support action when incarceration is a threat.
Okay.
Well, the court ducked. Imprisonment can result. And it seems to me that any situation where a defendant can be imprisoned, that if you fail to comply with child support requirements in some jurisdictions, you can be imprisoned. And if you can face imprisonment, I'd say that the principle of the Gideon case, which you should have a lawyer to assist you. Now, I recognize why there were arguments against it, but I think that should be the controlling principle.
Thank you. Others? Yes, Judge.
Could you expound, sir, a little bit more on your thought about why plea bargaining causes of ineffective assistance of counsel issues more than it did previously?
Well, you now have about 95% of, even more, I think, in the state, 95% of the cases are resolved through plea bargaining. And plea bargaining goes on. Look, a defendant doesn't have a right to a plea bargain, and the courts don't have a duty to accept it. I accept that. But the reality is that's the way cases are. That's the system we now have. Now, the Supreme Court has said that if a lawyer in a plea bargaining situation does not adequately advise the client of what for example, there was an immigration case in which the lawyer did not advise the client that if he pleaded guilty, he could be deported. Or egregious misadvice. But the question is, how can a court, the issue is this, how can a court supervise plea bargaining, which after all goes on behind closed doors? There's no record. And how does the court make sure that the defendant has a lawyer who's competent, who's investigated it? Now, one thing, for example, you can do is insist that the plea bargain be in writing, that there be an adequate opportunity to consider it, and that the defendant be adequately informed by the court of what the consequences of the plea bargaining are. But I suggest to you it's a very tough thing to know. How are you going to make sure that the lawyer who represents the defendant in a plea bargaining situation has done his job? I mean, it's a very, very difficult burden on the courts. Which bear in mind, the Supreme Court has now said, it's ruled several times now, that there's a constitutional right to effective assistance of counsel in plea bargaining. How is that going to be implemented? I think that's a big unknown here.
And Abe, you'll be glad to know that the judges did discuss this, and there was presentations about taking pleas, what judges need to go through, what questions they need to ask,
right.
Documentation.
Exactly.
So I think the issue that you have identified is before the minds of a lot of courts.
I suggest this is going to become a very critical issue in the years to come. I think the courts are becoming increasingly, because arguments are going to be increasingly made that lawyers, people are not adequately and competently represented, and how do you judge that? So that's a very tough, complex issue. Okay. And a lot of you know a lot more about that than I do, I should say.
Yeah. Okay. Thank you very much. We've run over time. Thank you for staying with us.